East Idaho Newsmakers is brought to you by the Bank of Commerce, your bank of a lifetime.
This is East Idaho Newsmakers with Nate Eaton.
Welcome to East Idaho Newsmakers. Today we are on location at the Bonneville County Courthouse. You can see we are here in an actual courtroom. We're so thrilled to have two judges with us. Judge Michelle Mallard, she is a magistrate judge, and Judge Dane Watkins. He is a district judge. To many of you, you may not know what that means. So we're going to talk about what that means, the legal system, and the questions many of you have about sentencings and court proceedings and everything. So judges, thank you so much for being here. Let's start off with how you got your position and what the difference is between a magistrate judge and a district judge. Judge Mallard, could you start us off?
So the procedures are very different. To become a magistrate judge, you make an application, and that goes in front of a magistrate commission. It's comprised of representatives from every county in the judicial district, so I think that's 10 counties: Custer County, Lemhi County, Bingham County, Bonneville County, Clark, all of them, Madison, Jefferson. Usually a county commissioner, maybe a mayor from the town, 2 attorney representatives, a magistrate judge, a district judge. So about 20 people that represent the entire judicial district out of each county. And if you're selected to interview, you interview in front of all those people. It's about 20 people. And in my case, every one of them asked me a question, I think. And then they convene and take a vote and vote on who they want to be the magistrate for that county.
Now, are you the only magistrate judge in Bonneville, in the district?
No, there are 3 magistrate judges in Bonneville County. The legislature, the Supreme Court this year, got us a 4th magistrate. So we'll have a new magistrate come October 1st. That will be our 4th Bonneville County magistrate. Most of the other surrounding counties have one magistrate judge per county.
What type of things are you doing as a magistrate judge versus what Judge Watkins would not be doing?
I do civil cases under $10,000, family law cases of any amount. They could involve millions of dollars. And then I do misdemeanor criminal cases. So that's primarily what my jurisdiction is.
And before you were a judge, you were?
I was an assistant U.S. attorney in federal court. I worked down in Pocatello under Tom Moss and Wendy Olson, who were the U.S. attorneys when I worked there. Okay,
so magistrate judges handle misdemeanor crimes. Judge Watkins, you are a district judge. Mm-hmm. What does that mean, and how did you get your job?
Sure. So a district judge is placed into office by election every 4 years. And as Judge Mallard said, the voting populace of the district judges in our district includes 10 counties. And so you face election every 4 years, and I'm in the middle of my 2nd term. And the jurisdiction of the district court includes felonies and civil disputes above $10,000 and things such as judicial review and appeals from the magistrate, whether it be a civil appeal or a criminal appeal.
So Judge Watkins and other district judges, which are how many in the district?
We have a total of, well, let's see, I'll have to count them. So there's 3 district judges here in Bonneville County, a district judge in Madison County, a district judge in Bingham County, and we recently received a district judge in Jefferson County. So those are the district judges.
And you all are handling the felony cases and the civil cases over 10 grand.
Correct.
Okay. So a crime is committed. Someone goes into a store and steals a lot of money and a lot of products. What happens once that person is arrested? Judge Mallard?
The Bonneville County Prosecutor's Office or the city, depending on the type of case and where it happened, reviews the police report and decides how they want to charge it. So it may, in your instance, if the dollar value of the amount of property taken is over $1,000, they may decide to charge that as a felony. If not, or as a burglary, in some cases, regardless of the money value. In other cases, it might be considered petty theft. So the prosecutor's office would decide whether it's charged as a misdemeanor or a felony, and all cases, regardless of how their charges, all criminal cases, come before the magistrate first. For arraignments in misdemeanor cases, in felony cases, it's called a first appearance. And in each of those cases, we tell them what they're charged with, what the penalties are, and we set a new hearing for them.
Okay, so if the crime remains a misdemeanor, it stays in your court.
Right.
If it's a felony, it then advances to Judge Watkins' court or a district judge's court. And does the proceeding continue as it would in magistrate, Judge Watkins?
Sure, there are a couple of different stages. What the magistrate will determine if an individual requests a preliminary hearing, and she described that, is evidence that would be produced enough to satisfy the magistrate that it should go into district court. And those are contested proceedings, and the magistrate presides over those. Individuals will often waive that stage of the proceeding, and if that's the case, then they go into district court. And once they get to district court, our first interaction with the accused is the arraignment. And at that hearing, it's the district judge that reads the prosecuting attorney's information, or an indictment if it's by grand jury, and at that time enters a plea, either guilty or not guilty. And if it's a not guilty plea, then the matter is set for a pretrial conference, usually about 2 months out. It can be based upon the convenience of the parties and the nature of the case, of how much time the parties are asking to prepare for the case. And following a pretrial conference, a jury trial follows that, usually a week or two after the pretrial conference.
Do judges ever determine the charges an individual should face?
Not initially. We may dismiss a count at preliminary hearing if there's not sufficient evidence for it to go forward into district court. There may be a motion to dismiss, perhaps.
Can you upcharge somebody? I don't know if that's the term.
Yeah, no, all of those decisions are made by the prosecuting attorney as to, what charges are appropriate. The court is left with the sentencing decisions if there is either a plea or a conviction following a verdict finding of the jury. But those decisions are made by the prosecuting attorney.
So when all of you on Facebook or on Twitter say, the judge should have charged him with this, or he should have been charged with 5 more counts, that's not in your hands.
No.
That's completely up to the prosecutor.
Yes.
Correct.
So Judge Watkins, you mentioned the sentencing. So the proceedings continue. The person has their preliminary hearing. There may be some pretrial conferences, or I guess one way to say it, hearings, I guess. Hearings, the person ends up pleading guilty or not guilty. Mm-hmm. And then what happens?
So if it's a not guilty plea, then it's set for trial, and if that's the case, then the parties are preparing for trial. Like you had said, that there might be some pretrial motions. We're trying to narrow some of the issues perhaps and get rulings from the court on evidentiary questions that might come up during the course of the trial, and that's fairly common. But once it is ready for trial, then it's submitted to the jury that is in this courtroom, and the case proceeds along through the course of the trial, and the jury receives the case, deliberates in one of our jury rooms, and deliberations can last as quickly or as long as the jury takes. I'm sure each of us have stories of the kind of the length of deliberations, some as quickly as an hour or two, and others multiple days of deliberations. And then upon that finding, if it's a acquittal, then that individual is free from the charge and released. If it's a conviction, then we set the matter for sentencing.
So the jury decides what the verdict should be, whether it's the person did the crime or did not do the crime. Does the jury then decide the sentence?
Not in Idaho. It would be left to the discretion of the court, and there are a number of factors that the court considers. Idaho has a lot of discretion given to its judges in sentencing. Some states, as you say, have guidelines that are either suggested or even mandated. In Idaho, there are very few laws that require a certain punishment for an offense. First-degree murder is one of those where there carries mandatory minimums. But in most instances, the offenses have a breadth of parameters that a court could sentence, and as Judge Mallard suggested, upon that review we're considering four major objectives of criminal punishment, and the court...
Which are?
Okay, so the first one is protection of society, and in every case the court will be looking for ways in which these objectives can be satisfied. And there really isn't an offense where protection of society couldn't be applicable in a case. Some have more relevance perhaps than others, but under our authority and statutes, it's that principle which is primary on the court's mind, protection of society. Then we look to deterrence to the individual, and how we get there is we're looking at, is there anything in that individual's past that has deterred them? So with increasing offenses, it becomes more of a challenge perhaps to deter that individual from other offenses. But sometimes that individual might be committing a certain nature of offenses and comes before the court on a different offense, and so you try to apply some analysis as to what would deter this individual from committing an offense. What's interesting about that objective is it's not limited only to what would deter that individual, but to others in the community at large. And so that's appropriate in some instances where a court may be considering how this sentence could deter others in the community from committing that particular offense. And then we focus on the individual's rehabilitation, and that over the last 10 to 15 years is increasingly important. It always has been there, but as our specialty courts have evolved, that's a very important factor and one we place great emphasis on. How can we help this offender rehabilitate into the community? And we can talk about that in a moment if you'd like. And then lastly, there just needs to be punishment for the wrongdoing. And that one is usually satisfied by the consequences of the offense, including the fine and incarceration.
Okay, so you consider all of that on every case. How long does it normally take you, once that verdict's come in that they were guilty, to come up with a sentence? I mean, are you going home that night and studying the case, or is it something that you go back to over the course of the next few weeks? What is it like for you?
For me, it's very different than in district court. For instance, today I've spent all day sentencing people on misdemeanors. That's what I did all day. I've probably handled 60 or 70 cases, and I sentenced each one of those people based on the file that was put in front of me, and that was the first time I saw it.
And you do it right there?
And I do it right there. And I have about 5 minutes apiece to do it, if I'm lucky. But you know, my tools in each case are limited. I can give them a fine. I can put them in jail. I can put them on probation and make sure they get maybe a substance abuse evaluation and treatment, or other treatment or training, rehabilitation, or I can just give them a fine, no probation. So I only have a very limited toolbox of what I can apply. So some things like driving under the influence, almost everybody's going to get put on formal probation. They're going to get a drug and alcohol evaluation. They're going to be put on formal probation so that a probation officer makes sure that they do all of those things. I will often give them community service. And as Judge Watkins noted, rehabilitation has become increasingly important, and that's because over the years we've learned through research excuse me, that rehabilitation is the best way to protect society. So they're really hard to distinguish from each other. So I don't have a report like he does. I have the police report and I have the defense attorney in front of me arguing the case. I don't have a prosecutor arguing the case. I have the plea agreement in front of me, and from that I have to decide what the sentence should be. Right there.
Whereas a district judge would have a pre-sentence report and sometimes a psychosexual evaluation if it's a sex crime, or other reports that you might order.
Right. Mental health evaluations, substance abuse evaluations. It depends on the nature of the offense, but you're correct in that there is a report that's generated, and it's significant. It's probably about that thick on every single felony. And a number of materials that the court is reviewing. It'll include information such as a prior criminal history, and that's always an important one. History of substance abuses and treatment, education, family, social, and the court reviews all of that, digests it. I'll read pre-sentence investigation reports days in advance of sentencing, and then when the sentencing occurs, as Judge Mallard said, there's argument about what the appropriate sentence is, and you'll take the state's recommendation, listen to the defendant's recommendation through counsel, and then the defendant is always given the right to make a statement, and that is important in my mind. I listen very carefully to hear the kinds of things that I would be looking for, which would be remorse and oftentimes apologies to those that have been harmed or hurt. And then the court issues the decision. Many times the parties have agreed and are asking the court to follow their recommendations. That occurs in most cases where there's some sort of agreement in place. Sometimes it's the reduction of a charge, or it might be to negotiate a certain recommended sentence. And then the court has discretion. I can sentence to follow the agreement or not. If I'm being asked specifically, then it's called a binding agreement, and the parties are suggesting, Judge, you have to follow this agreement, and if you don't, then the agreement does not proceed, and the parties go back to that stage prior to trial. And those are not as common, but we see them probably a couple of times a month.
How about personally? I mean, are there cases that you go home and you can't stop thinking about?
Absolutely. I wouldn't be honest if I shared that it doesn't have an effect on me. And it depends on the nature of the case. The judge is impartial, disinterested, and trying to make decisions that are based in law and fact. But the courtroom is, a place where drama unfolds, and you get a real sense as to the emotions that are involved, both in civil and criminal cases. It's not just in criminal cases where there are heightened sensitivities of feelings and emotions. I'm sure that's the case in family law matters, when you're talking about property or custody of children. And so you want to make the right decision, and when you've made that decision, many times I've stepped off the bench and thought, have they done the right thing on this case? And in terms of dealing with it, I think every judge has to have some method to cope and deal with these kinds of decisions. And for me, it includes family and
biking,
exercising, and releasing a lot of that tension and energy, and just methods to reset and be prepared for the next day.
Judge Mallard?
It is, it's trying to make sure that you've done the right thing, especially in misdemeanor court. You've got people there sometimes who have never been in court before, and they've got a DUI and they're 45 years old and they're scared to death. And you know that you're probably not going to have to do much with them to make sure this doesn't happen again. But you get a 21-year-old who has a long series of petty offenses behind them, and the question is, do I do too much and do damage? Do I do too little and cause harm to society by not putting them away? So it's always in the back of your mind, am I being too harsh? Am I being too lenient? And it's really hard to know if you've done the right thing, and you can't avoid the fact that this is an individual in front of you who's had, their own problems, their own successes. Their families may be good, their families may be bad, they may have support, they may not have support. So it's a big responsibility, and I cope with it by trying to treat everybody who comes into the courtroom with respect and courtesy. I think everyone deserves that when they come into our justice system. And same thing, exercise and family and faith, and just trying to do the best you can and be as respectful to everybody entering the system as you can be.
Do you ever have someone who comes up to you years later at Target or Albertsons and says, you were the judge, and they thank you, or they chew you out?
Yeah, it's a small community.
Yeah. And
lots of different places, in a restaurant, in Walmart, at other grocery stores, and it's a rewarding thing when you have an individual, number one, that you see in the community, because that's a good thing, that they're not in custody any longer, and when they acknowledge the journey that they were on that held them accountable and they grew through the process, it's very, very rewarding.
I had somebody tell me just yesterday, Judge Mallard, you're my favorite judge in the hallways here. And this guy has experience. So we do get to know, a lot of, especially in misdemeanor court, we see a lot of people. And people will have a run of problems. And so you get to be pretty familiar with them, and they run into you, and they like to let you know if they're doing well. And if they're not, they duck and try to avoid you.
Have you ever been scared for your life? Like you sentence someone and you go home and you're a little worried that...
Yeah, and those ones are a little more difficult to talk about. The reality is that you make decisions that affect people's lives, and it may be that individual specifically that may not be happy, to put it mildly, with your decision, and may garner some resentment towards that. But sometimes it may be a loved one of that individual that came before you that wasn't pleased, that expresses in one way or another that they're not pleased, and that it's part of the job of being a judge, and you have to be prepared to make those kinds of decisions, but it happens.
It does happen. We have an excellent marshals contingent here. They take good care of us if there's anything specific going on. And so I mean, there have been times when I've worried about somebody coming after me or my family, and like Judge Watkins says, it's a very small town. It takes almost no effort to find any of the judges here. But the other thing that I also tell people is when I'm in the courtroom, there will on occasion be somebody who's really upset, really out of control. And if there are other inmates in the courtroom, I tell people I know that a good share of those inmates would protect me as much as the marshals would, because they do, they feel pretty protective of the judges most of the time.
Idaho is unique, maybe, compared to other states in that there are these specialty courts. Before we get there, explain what a rider is, retained jurisdiction, because we hear it so much and we put a little write-up of what it is, like in a sentence, but how would you all describe that?
Well, it only happens in district court, and it's always changing, so I'll let him.
So Judge Mallard earlier talked about the tools that are available for sentencing. In a district court case, there are really three options that a judge has after considering these four objectives of criminal punishment we talked about. One is probation, and what that is supervision in the community, someone who is subject to rules and restrictions placed upon them by the judge, which may include limitations on travel, limitations on associations of people they can't associate with. It may include curfews. It may include, and obviously in certain cases would include abstinence from alcohol or drugs or controlled substances, medications. And so that supervision occurs in the community. If someone does well, then they succeed along the way and ultimately are released from probation and have the case either entered at the end of their term as a conviction or a dismissal or a reduction to a misdemeanor. So that's one tool, probation. The most significant or severe is prison. And the rider is what is in between those two things. And so a judge, by statute, can retain jurisdiction over the individual for up to 365 days. And when we do that, we're placing them temporarily in the Department of Corrections facility for custody and for programming. And the beauty of a retained jurisdiction, and it's common, very common, and today, as much as any, are we sending a lot of individuals on retained jurisdictions, or also called riders. And the beauty of a retained jurisdiction is a judge doesn't have to make the decision on the bench at that time as to whether this person is ripe to be placed into the community. We can send them on a retained jurisdiction, see how they respond to what they're being asked to do, which is programming and the stringence of being in custody, receive a report at the end of that term, and then say, well, I don't think you're prepared for supervision in the community. And at that time, then they will be placed into the department and go to prison. Or if the court says you've done well on the retained jurisdiction, we'll place you on the community. And it's up to 365 days. And the Department of Corrections has various programs that they work individuals through during that term. And so there are obviously cases that come before a district judge that are ripe for probation, someone with no prior criminal history that's working on substance abuses or addictions. There are other offenses where retained jurisdiction would never be considered, a more serious offense where it's a prison case. And then there are a number of cases in between where you want to see how someone responds.
So many people, when writers are given, say, they should have gone straight to prison. You should have locked them up. Are writers giving out too much, or is it more of a way to hopefully find the right gauge for this specific individual?
I think it's the right gauge, and as I said earlier, there are some cases where a retained jurisdiction would not be appropriate. But there are certain requirements before a judge is satisfied that placement in the community is appropriate that would need to be satisfied. For example, if a viewer is concerned that someone who perpetrated a sex offense got a retained jurisdiction, they may be required to undergo all of those same evaluations and testing and polygraphs and things that would need to be in their favor before the court would be satisfied that placement in the community is appropriate. And the judge can put off that decision for a period of time until that report comes in. So that I would consider the retained jurisdiction a safety net of a decision before that person is in the community again.
Talk about drug court, and what are the other specialty courts? We hear about drug court and mental health court.
I preside over a domestic violence drug court, so people have to have substance abuse issues, mental health issues, and domestic violence issues.
And then they're automatically assigned to your court.
Right. We have a family drug court, a juvenile court, a young adult court, veterans court now, wood pilot.
And what would set these courts apart from just regular court?
In a specialty court, we usually have, I mean, the numbers vary, but in my court, I usually have about 20 to 25 participants. I see them every week for a year, and I make sure they're doing exactly what they're supposed to do every week. They phase up so that they attend court less often throughout that year. But those people in that specialty court get that judge's individual attention and an entire team of treatment providers, probation officers, law enforcement. In my case, I have victims, advocates, prosecutors, defense attorneys. We all bring information to the table and hold them accountable every single week. So these are people who would maybe be going to prison if we didn't have such intense supervision on them and accountability. It's immediate accountability. So if they do something wrong, they get sentenced the next week.
Oh, wow.
Instead of 6 months later.
In my opinion, the real joy of being a judge comes in the work in the specialty court. An individual may come before the court, and I may never see that individual again. Maybe I will when they come back after their term of probation, which may be 2, 3, 4, 10 years later. But it's uncommon. The nice thing about a specialty court, as Judge Mallard said, is you have that weekly interaction with the individual. And these are, I preside over the wood court, and so what's the wood court? So the wood court is funded by the state a little differently from the other courts, but it's a dual diagnosis court with substance abuse and mental health. And it's essentially the last option before prison. And most of the population of the wood court have been to prison, and we're just trying to find a way to keep them from going back to prison. And so we work with them regularly and see them regularly on things such as employment, their housing, their treatment, and they're making appearances. They're working on their family, relationships, and when they do well, they advance from phase to phase, and you see people reestablish employment and relationships, and ultimately, if they can graduate, then it's a beautiful thing. Watching people graduate through these programs is something you'll never forget, because they have succeeded and they've done it with all of the things we've asked them to do, and it's very significant, and it's very rewarding, and there's a camaraderie. The other court that was mentioned is the Veterans Court, and that's our newest court, and that has been a wonderful addition to our community, because each one of these courts takes characteristics of individuals and tries to plug them into a court that will allow them to succeed in the community. Domestic violence is what Judge Mallard presides over. And the vet court has been fantastic, because we have veterans now who are feeling the support, the fellow support of veterans. And it's just terrific to see people succeed for the first time. I mean, in a typical Veterans Day, we talk about their length of sobriety, and you'll have individuals, just yesterday in a veterans court, or in my Wood court, actually 2 days ago, we're talking about sobriety for individuals who have not had it since they were teenagers, and this was a 55-year-old man because of the efforts in the specialty court. So it's terrific.
I think that many people don't understand that there are a lot of people in our community who have not had normal, healthy upbringings. They don't have any of the tools they need to succeed in our community. And so, like in my court, I had 2 graduations yesterday. It was wonderful. Their families were there. You know, they hadn't been in criminal trouble. They'd been sober for a year, which was huge, like Judge Watkins said, for these people. But I once had a participant say to me, I said, so what have you learned, you know, from your treatment, your group treatment that you've been getting? And he says, well, I never knew that there were men who didn't hit their wives. And he was honest about that. He had been raised in a way that he didn't understand that there were other ways to act in relationships. And so these specialty courts really give people who have not had the advantages of most of us of a normal, healthy upbringing the tools to understand a different way of living from what they've experienced.
Biggest thing you've learned as a judge?
There are a lot of problems in the world. There are a lot of problems in the world. There are a lot of people who struggle against those problems and don't prevail over them. And we can either put a foot on their neck or we can give them a hand up. And Bonneville County is great at giving people a hand up. We've got a wonderful misdemeanor probation program that really helps people sort of fix their problems and prevent them from ever getting to Judge Watkins' court.
Judge Watkins?
I think it's just a general appreciation for our system. And I know that our judicial system is criticized, and there are reasons to criticize it. But as I sit in these courtrooms every day, and you watch the kinds of confrontations that exist, whether it's in the civil arena or in the criminal, and watch it unfold. And it's sometimes a messy process, but I'm convinced it's a wonderful process. It's one that works. We have competing, you know, advocacy and antagonistic views that get resolved in this courtroom under the rule of law and order. So I appreciate that. And then also, as it relates to individuals themselves, I think I would say that we are all imperfect, we are all flawed, and those that in criminal matters appear before the court, as you learn their history, it gives you a better sense as to maybe why these things are occurring. And yes, they need to be held accountable, but how can we help them to ensure that they never have to come back into the courtroom again?
District Judge Dane Watkins and Magistrate Judge Michelle Mallard. I could talk with you for another hour or so, but we're out of time. Thanks so much for watching East Idaho Newsmakers. We'll be back next week with another show. Have a good week.
East Idaho Newsmakers is brought to you by the Bank of Commerce, your bank of a lifetime.